the Attorney General, Dr. Dominic Ayine, he last week issued a statement announcing that Dr. Kwabena Dufo and 7 others were standing trial over the Uni Bank collapse, or the revocation of the license of Uni Bank, were free, and that they had a structured payment process for what they were liable for. So we start with you, Bright. You're going to make a presentation in some 15 minutes, and then I'll come into the studio. We'll spend a bit more time also with Kwame Boafo-Akufu, and then our guests will all join to share their views on this subject matter. But what do you say? You spoke too early when you wrote your article suggesting that the recovery so far would have been, or what the Attorney General is talking about, would be only 10% instead of the 60% that he said that he was able to obtain for the Republic. You think you spoke too early from the facts and the information that have now come to our, knowledge?
Not at all. And I think by the time I'm done with my presentation, it will be very apparent that some people have been having a different conversation from those of us that are talking about liability to the country as a whole versus the specific cost proceedings. And Samson, I'm very grateful that I have the opportunity to do this presentation. I'll start off by saying that, when you think of a bank, like any other organization, any other commercial entity, you've got assets and you've got liabilities, right? And for a bank, what confuses a lot of people is that the deposits that you go and put in the bank is not an asset of the bank. It's a liability of the bank. It's almost like a debt. It's a loan you give to the bank. And obviously, the bank then gives out loans, and those loans are the bank's main assets. Of course, the bank can also borrow money to on-lend, and if they borrow the money, that money will also be liabilities or debts. Let's just use that term, debt. And then their shareholders themselves to put in some money, because without significant equity as a shareholder, you're not allowed to start a bank in the first place. So that's the starting point. Now, the point about the shareholders putting in money is very important, and I will explain in a minute why that's so critical. For banks, you need shareholders to put in a minimum amount of money, which is not the case in many other businesses. And the reason is because banks have a very particular risk attached to them due to the fact that the money that we put there as deposits, when they lend it out, they do so pretending, so this is like a magical kind of thing, pretending as if that amount of money, even though it's a call deposit, I can come in and pick it up anytime I want. They make it look, they pretend as if that money is being given to them for long term, but it's not really long term. I can show up tomorrow to pick up the money. Yet they often lend it out long term, 5 years, 2 years, 1 year, whatever. So because of this delicacy around the way banks are structured, you need what we call prudential regulations to be extremely strict, otherwise you get trouble. So this is where we get into the Uni Bank matter. Essentially, the way banks have been structured as public utilities, because of the delicacy of the whole operation and the risks that are attached, banks cannot be run like any other business, is the point I'm trying to make. So we get into Uni Bank, which is a bank that, until 2017, actually until 2018, was regarded as one of the best banks in Ghana, one of the best growing. It was, very often on the Club 100, which is the list of most prestigious banks in the country. It had 370,000 individual customer accounts and over 400,000 accounts if you count the corporate and other accounts. $1.25 billion in assets. Is a big bank, essentially. And if you go to December 2016 and you look at the balance sheet of Uni Bank, absolutely nothing was out of gear. Everything seemed to be in place. It was a bank that was doing very well and seemed very profitable, as you can see on the balance sheet, in terms of the total equity, way above the minimum equity that was then required, etc. What we didn't know until much later was that certain aspects of this balance sheet that you see was not actually what it is. Essentially, these audited financial statements that were published, it was also a listed company on the stock market, and therefore it had rules that it had to comply with. Some of that stuff was not correct. So I'll give you an example. Even though it was seriously on liquidity support, chronic liquidity support from the Bank of Ghana that was not somehow reflected on its statement. So you wouldn't really see the full extent of its liabilities if you look at the statement. And certainly that situation worsened in 2017, where it moved from about 850 million Ghana cedis to over 1 billion Ghana cedis in terms of monthly support that it was getting from the Bank of, in terms of annual support that it was getting from the Bank of Ghana. On top of that, when you look at its regulatory disclosures, what it was telling the regulators, it suggested that its non-performing loans was just about 5.34%. This was December 2016. The truth, in fact, was that things were far worse at the bank than anybody knew, because its disclosures, what it was publishing in audited accounts and the rest of it, were not correct. So, for instance, as of 31st December 2017, the Banking Supervision Department of the Bank of Ghana, based on the audits that they did subsequently when these matters came to their attention, showed that they had overstated the loans that they were publicizing by about 1.3 billion Ghana cedis. And that some of the loans that they had actually given out under the so-called other assets category, most of which had gone to their own companies that they owned, had also been understated by about 3.8 billion. And that customer deposits is actually quite frightening. Customer deposits balance had been understated by up to 2.3 billion. So in those days, that amount of money was in excess of $500 million. So there were about $500 million of customer deposits that they just simply were not disclosing to the Bank of Ghana. Later on, Uni Bank will suggest that part of it was due to a problem with their banking system. They had the Terminus software, and they did a cutoff, and it caused chaos in their numbers, etc., etc. Whatever be the excuse, the truth of the matter was that we did not really know what was going on in this bank, even though it was an audit. It was a bank that was listed on the stock exchange. It was audited and was regularly supervised by the Bank of Ghana. It was later when it came under heightened scrutiny, the Bank of Ghana was sending people there almost every month to audit, that they began to understand the real problem that was going on. Secondly, there was also significant activities, in this bank where, for instance, they had borrowed money significant from international banks like Afrexim Bank to achieve particular purposes and were using for something else, etc. But the key principle is this bank was such a big bank that it was systematically important. What that means is when you are looking at it as a regulator, you're not only looking at the bank in terms of its own situation. You're looking at the impact it can have on the entire financial system. And part of the reason was because it had exposures and etc. to other banks, some of which I've listed like ADB, GCB, etc. And therefore, Prudential Bank, for instance, was heavily exposed to it. And if you didn't manage Uni Bank properly, you're going to damage the entire financial system. So the question really here is that we had a bank, it had huge problems. Because banks are not like normal business, you can't just shut them down and walk away. The government has to step in and clean up after the bank. So my point is, how much has the country lost as a consequence of cleaning up after the bank in ways in which we could not have avoided? And then on top of that, how much of that money could potentially still be with the former shareholders? And therefore, what is the fair amount to recoup? It's a different question from the question that I think a lot of people are asking, which is what is the amount that the government was trying to get in court, etc. And I will explain why there's a fundamental difference between the two discussions in a minute. But the simple reality is that you simply have to go to the latest analysis of the balance sheet of Uni Bank, basically what it owned and what it owes, right? As of March 2025, that is the latest that is publicly available. So March 2025 is later than some of the court documents that I've seen flying around, which dates to 2024. So when you look at the numbers that have been, analyzed and assessed by the by the receiver, by that point, you come to the conclusion that we had a certain amount of money that as a country we put behind the attempt to clean up after Uni Bank. And that really is what we are looking at. So when you look at on this balance sheet that I'm just displaying, it's very simple. How much of the money that you can categorize as assets, which was money you can really rely on, was at Uni Bank by the time that it was transferred to some of its liabilities and assets were transferred to CBG. Because most people know that. Most people know that the government more or less took some of the deposits, in fact, all the deposits, and some other liabilities, very few liabilities, sent them to CBG and some good assets. How much do we get when we try to clean up? And when you look at that figure, it's on this chart right here, which is from the receivers. It was literally about 711 million. But the critical point is that when you look at Uni Bank's balance sheet, it tells you what it borrowed in terms of deposits, the money that people went to put there. It borrowed from other banks, it borrowed from the Bank of Ghana, and what it bought with what it borrowed. Because when you, in a business, it's very simple. You take money from other people and you invest it into assets that create money. So what you borrow, it's in this case of a bank, is the deposits people put there, it's what the Bank of Ghana gave them as support, it's what they borrow from other banks, and then they must use that money to buy assets, which then generates money. What are some of these assets? Loans you make. It's a very good example. Treasury bills you buy, etc. So when you look at the proper assets that were transferred to CBG, and this is all data that has been analyzed as of March 2015, there's only about 711 million that went to CBG. The rest of it have to be adjusted. And when you adjust and you adjust and you look at the impairments, the money that we can't find, the money that we can't trace, etc., you come to the conclusion that as much as about 7 billion Ghana cedis. Remember though that this is 7 billion Ghana cedis frozen at 2018. That point will be important. I'll come back to that. Nearly 7 billion cedis could not be traced or was not available to hand over to CBG. And somehow, in different ways, this country has absorbed that loss. How did we absorb that loss? All the deposits that you had in Uni Bank, over 4 billion, which is about $1 billion at that time, that deposits, the government had to make sure those deposits were good. The money that the Bank of Ghana had lent to them, which is in excess of 3.something billion, and if you take the unsecured portion alone, essentially you offset it with what Uni Bank had with Bank of Ghana, it's almost 3 billion. That money can still not be recouped and given to the CBG. So you add all of that together, that is what I am talking about. So I'm talking about the money that the country has lost. When it comes to what the government tried to retrieve in court, they were focused on things they can prove emphatically within that adversarial process, which is the courtroom. And that's not the only place in which accountability is handled. And that is the difference between my analysis and some of the analysis that I've seen flying around. So essentially, you go into the Unibank books and you try to understand where did the money go. And that is where you begin to notice that a lot of the money eventually went to related parties. Essentially went to companies that are very closely related to Unibank. And then some of it also, due to the way in which those approvals were made, there was a belief that a high degree of liability attached to Unibank's senior executives and shareholders. And therefore, if we went to court and we said for these amounts of money, the court should help us to pull back, we'll stand a better chance of prevailing in the court. That's not the same as trying to trace the money we cannot at this stage put our hands on and pass on to CBG. That's a different conversation. So you say, okay, there is a lot of money missing. Some of that money, we know it went to companies that these same shareholders own. And I will show you a couple of them very soon. And so we can trace that money easily. And then some of them too, we can see that they've signed some documents and things like that. And we can pile all of that and we take it to court and say, look, for these amounts of money, we think these people should pay that money back. And this is a purely litigation strategy, a prosecution strategy. It is not entirely encapsulating all the money that this country has lost because we have to step in and clean up after Unibank. And that's a critical point that I'm trying to make. So the 7 billion that you saw on that page is not necessarily the 7 billion that is being pursued in court. It's money that through Unibank's various infractions and negligence, and maybe misfortunes as well, could not be traced and handed over to CBG. And for which reason this country had to step in and make good. And that really is the logic. So once that logic becomes clear, then the matter of separating that from the issue that everybody else seems to be focusing on, which is how much money did we trace to different companies that were owned by the same shareholders who owned Unibank, and how much of that reconciliation has been done, how much of that has been separated into monies that we've now traced to other companies, and we think we can target them directly. And I'll come to that point very soon. There are over 90 lawsuits that the receiver has filed chasing different companies directly. So in some of those instances, there's no point then in a courtroom to insist that, you are asking the judge to rule that this particular company is guilty of those particular infractions. And that differences, I think, is what's confusing people. But when you look on this sheet, for instance, you will see that there are a number of big companies that are owned by the same shareholders who were the majority shareholders in Uni Bank. So Numa Logistics, for instance, the associated funds, the other assets category, the money that somehow went to them is almost 1.7 billion. So essentially, we are talking of something like $400 million of Unibank's money going to this other company through various schemes and devices. Holder Holdings, which has many, many properties all over Accra and different parts of the country. There's a lot of integrated properties, Uni Precision Printing, LHS, Urban Logistics. There were almost 30 companies that the owners of Unibank also owned that have received different kinds of support from Unibank. Some of them are letters of credit, some of them are whatever, some of them are loans, some of them are advances, etc., etc. Now, the analysis moves from how much money has this country lost in attempting to clean up behind Unibank to why I think that there's more money with the owners of Unibank or the former owners of Unibank, and therefore we should aim for more. Part of it is you have to look at the analysis of how some of that money moved to some of these companies. So there are companies like I've mentioned, Holder Holdings, Yawado, Numa Logistics, etc. And in many of these instances, the money was created out of thin air. So when the Attorney General says that the money that was lent to them was basically fictitious entries and we shouldn't repeat them, he's misunderstanding the issue. The fictitious entries were the credits. So essentially, you pretend that there's money there that you are lending to someone, but actually you are using deposits to lend to that person. So it's not backed by full credits. So your liabilities are expanding without a corresponding increase in your assets. That's really what was happening. But it doesn't mean that the money didn't go to these companies. The money did go to these companies. We have all the records from the work that the receivers and before that the official administrator had done that establishes that. There were also monies that, for instance, they had used to buy insurance companies in Sierra Leone. They attempted to buy ADB, for instance, and they had moved the money into some other account because they wanted to buy a contract development bank. It's a whole range of activities where the monies had moved. Now, in some instances, we can't literally trace them. And I'll come to that point because it's very critical. It's not very clear who these entities are that have borrowed the money. It's been very difficult reaching them. We don't know how many of them are actually going concerns, and that made it very challenging. Some of the money too came from international. So Afrexim Bank, like I've told you, lent money that was supposed to go to LHS and BOST to do oil business, and that money somehow ended up not going to them. So all of that to say that when eventually all these facts came out, and the shareholders themselves were then confronted with the blatant evidence on record, they came up and admitted some liability, and they made proposals to put some money in the bank. Right. I've heard people talk about 2 billion Ghana cedis. That was not the only amount that they offered at that time. Remember that 2 billion Ghana cedis in 2018 was far higher than 2 billion cedis today. And I'll come back to that point again. When they made the offer of 2 billion cedis in 2018, they also offered to put 4.1 billion cedis of assets belonging to Holder, which is their holding company, which owns a lot of companies in Ghana, into the bank in order to patch up the bank. So when you look at what they themselves were willing to offer at that time, it was in excess of 6 billion. And that tells you the hole that was there and what the shareholders felt they could do in order obviously to avoid prosecution and in order to keep some of their other assets because the receivers were going after everything, right? So that tells you the scope of the liability that they were willing to admit at that time. And that was very important. And then when you look at why that proposal was not accepted, it tells you the scope of the problem. Because even that was considered not enough to close all the gaps, which is what you see on the left side of the screen, which were the gaps that will remain. There will still be a capital deficit, even if all those monies came back from the shareholders and went back into the bank. So that's very critical. Right. And the reason why it's important to use dollars in order to get the right sense of the recovery is because 2018, a CD was worth more than a CD today. If I give you a CD in 2018 and you simply just put it in treasury bills, by now you have way more. So if somebody owes us money from 2018 and is paying now without interest, it's an interest-free loan. So if you are doing the analysis properly, the simplest way, there are a lot of methods you can use, DCF methods, like a whole bunch of methods, but the simplest way to discount it and to kind of make the analysis a bit more wieldy is to take the dollar value then and the dollar value of what you are paying now. So when you strike the balance of that $7 billion that is missing in those days and how much in dollars it's worth, and the $2 billion that is being offered today, you get the point that I'm making around the 10% entry, because the dollar values then change and the ratio becomes clear. Remember also that they are not paying all the $2 billion at once. They are paying 800 million cedis in property, which nobody has valued. And then over 18 months,
nobody has valued.
The government is hoping to recover some of the monies that have gone to other parties other than the related parties, which is exactly the same challenge the receiver has been on all along. So the critical issues, let's summarize again. By the time that the government went into to close,
so you are summarizing to conclude for me.
Yes, give me a few minutes. By that time, the liabilities, the total liabilities of Uni Bank, as you can see on the screen, was $9.4 billion. That's in excess of $2 billion. That was really what the issue was. And then the question was, how much of the money could you find in treasury bills, etc., in money that was in cash, etc. And then that money was about $2 billion. So if you take that out, you are left with the 7 billion cedis that I'm talking about. And then you look at where the money went, because essentially if you have all these liabilities, there must be corresponding assets. You find that a lot of it went to companies such as Numa, Holder, Integrated, Uni Precision. Some of those companies today, like Uni Precision, the name has been changed. The asset in a way has become encumbered because the same shareholders have taken some loan from some company in some tax haven, and therefore they claim that they don't own it anymore. And even though they have rented the property out to some people, they have moved them. So a lot of the assets have become complicated, but the truth of the matter is that there's money that is in all of these companies. And in my view, given the money that went into them, it is very difficult to argue that the money that we are getting from them, which at this stage, in terms of the actual hardcore cash of about $60 million, is enough when the country has lost over almost $1.5 billion trying to clean up after Uni Bank. In terms of the debt owed, people have said that, okay, Uni Bank also, the government owed Uni Bank. Why don't you offset that? All that was calculated. Uni Bank itself, when it brought its numbers, was less than $1 billion in those days. That's cedis. And then, subsequently, there was validation at the Ministry of Finance, and that ended up with only about half of that. So that $500 million that the government owed them, when you offset, is when you still get these numbers that I'm talking about. Now, here is our problem with the AG's intervention, the Attorney General's intervention. The receiver that was appointed, he was appointed according to law. The law gives the receiver certain powers in Act 930, which is the Bank's Specialized Deposit Institutions Act. It's the receiver's job to go and get the money back and to maximize the recoveries. It's not anybody's job. The AG was just helping by filing the criminal lawsuit, which should have played a role of piling pressure on the shareholders or the former shareholders of Uni Bank. It was not the job of the AG to collect the money. It's the job of the receiver to collect the money according to law. On top of that, the same law also gives the receiver the power to disallow transactions that happen before receivership. So, for instance, all these related party things and the rest, that's why the receiver has a separate civil lawsuit ongoing. So, for the AG to now enter in an attempt, in a way, to preempt what the receiver might do, to us is overreaching. It's acting clearly in excess of jurisdiction. Okay. The other point is also that the receiver has fiduciary responsibility to the Bank of Ghana. It's the Bank of Ghana that appoints the receiver. So if the Bank of Ghana itself has determined, this is a matter that has been well established in the Supreme Court case in 2023, where the current acting CJ himself reinforced the fact that the receiver acts as a fiduciary of the Bank of Ghana. So really, only the Bank of Ghana can terminate the receivership when the receiver has determined that he cannot recover any more money. And we should also remember that, as I've already mentioned, there are several lawsuits that are ongoing, target direct individuals. And if we continue to make this kind of arrangement, then what are we telling all the other people that are also owing the company receivership? Okay. Essentially, if you're going to make a pact to one set of creditors, what about the rest? Okay. Are they all the 90 people that are being pursued? Are they also going to get a deal that says they should bring 50% or 30%? So really, this is a very serious problem. Right.
Thank you, Bright. We've done some 20 minutes already, but thank you for this presentation. That's comprehensive. But I'm interested in one small point before I come to Kwame Akufo. you have been relying on a particular document heavily to talk about the banks concerning bad circumstances in 2017.
No, I've been relying
That's
on
the
multiple,
KPMG report, correct?
No, I've been relying on multiple documents. As you can see.
Yes, but I mean the document that you rely on mostly is the KPMG report.
No. There was a KPMG report in May 2018 when the receivership was initiated. Because by law, within a certain short period of time, you have to issue something. And then in August, within 3 months by law, you are also supposed to issue another report. So there was another August report. Then there's a 2019 report, which is more than a year after another analysis.
Right.
What I just told you, most of those screens come from the report, the reconciliations done as of March 2025. So anybody who suggests to you that some documents that was in the courts last year overrides what I'm talking about doesn't know, that hasn't actually done his homework. So 2025 has been reconciliation, and that is the data that I'm relying on.
Okay, because I was going to ask the question if you had paid attention to the caveat, very significant caveat that they issued in that KPMG report. They said that we have not sought to verify information or performed procedures necessary to express an audit opinion on any financial or non-financial information contained in this report. Accordingly, we are unable to determine the extent to which information provided to us are complete and accurate, and the report should be read in that context. And so, on the basis of that, if they do a further review from what they had done originally at 4.97 billion, and then eventually came to 5.7 billion, and then more recently do the reconciliation again and come to 3.3 billion. And they clearly show us the path why you can say without any doubt that the real debt amount in cash sort of is only 3.3. So I'm having a difficulty appreciating how you arrive at your calculations, which now impugns the work done by KPMG, the receiver, the administrator, and the receiver now. Okay,
so 3 different questions. First question, the disclaimers that they put in those reports are standard disclaimers because they don't want to be sued and held personally liable. So if you give them an engagement and you sign an engagement letter with them, based on that engagement letter, they are telling you that, you know, those we will not be held liable for anybody suing us, so you indemnify us.
Okay.
And it's not in only one document, it's in several documents over a long period of time. So it's not like if they started with that and then the subsequent document, they remove that disclaimer. All the KPMG documents you will see have those disclaimers because they are indemnification that they need for their own protection. So that's number one. Number two, we were not using data from 2018 that has changed. The data that I showed you goes all the way to March 2025, and everybody can go to the receiver's website and look at the latest reconciled information. And they'll see that by March 2025, the capital issue that I just described, the capital deficit issue that I just described, are exactly what they are. And I'm happy also to send you the document that I've just used, and you can put that on your website. The third question around, you know, where am I getting my information from? The confusion that people have is that because they went to court, and in the court process tried to retrieve some amount of money, every time they decide that, okay, rather than use this particular criminal proceeding to do that task, we will simply pursue some other individual directly. People confuse that to mean they've revised it to say the money is not lost. No. There are about 90 different lawsuits in which they are pursuing different obligees, people that have obligations and other liabilities to Uni Bank. And those are separate matters. So if they decide that instead of, you know, chasing this particular individual, we're going to chase somebody else, it doesn't mean that the money is not missing. And that is, I think, what we have to clarify for people.
I've a good number of questions for you, but because we have done quite extensively with you so far, and I have other guests in the studio, let me come to the studio. Otherwise, we have to note that the AG insists that he took a pragmatic and holistic approach, and that as far as he can see, 100% recovery was not possible, and a conviction was not guaranteed. And that's how come he brings us the bait capital situation, which I understand they will appeal anyway, where he had the opportunity of taking 10 million and he refused. And then eventually, we've lost that case. So he gets 0 in that regard. And to think that both the criminal and civil cases have persisted for over 6 years with no immediate resolution in sight, he believed that this is a best approach. When they give us, by their own calculation, what amounted to the 5.7 billion, they clearly show us that out of that amount, the reason you have a reconciliation that now results in 3.3 billion is because a total of 2.4 billion has been excluded from that amount. And the exclusion is as a result of the fact that 2.1 billion is alleged fictitious amount that were only, cooked in the books. They are not, actual cash outflows. And then the 3 million extra is money relating to Uni Bank's placement with the Securities and Exchange Commission. They regulate that aspect. It has nothing to do with the Bank of Ghana, and they are pursuing that separately. So with just that out of the way, let me ask Kwame Akufo. From Bright's, analysis, he has a total debt amount of 9.4 billion, separate from, completely different from the 5.7, which became the amount that was being worked with, and which has gone through the reconciliation up to this point. He says we didn't get, a good bargain.
First and foremost, let me say that Bright has had quite a significant advantage sitting at home and has set out his case. For we lawyers, it's as if he's filed pleadings and we don't have pleadings and we have to speak to him. Because he sat back at home and said that a huge table, put his case together and we have to respond. But we'll respond to his case. First and foremost, it's important to understand that we operate within a system of law. That's the most important thing. We don't operate within a system of self-serving, homemade arguments, which is thrown at the other side. That's not the system we operate on. Secondly, what Bright says, or Bright by Simon says, does not have the tag of a presumption of propriety. Under Section 37 of our Evidence Act, documents emanating from official sources in terms of a report have that presumption of legitimacy. We have a situation where the Attorney General of the Republic of Ghana and officials or agencies appointed by the Republic have carried out an official duty. That official duty has a presumption of regularity. Mr. Simon's work does not have that presumption of regularity. So raised against that which is a presumption of regularity, that which has a presumption of regularity should supersede. Because if we are to follow his example, everybody will sit at home and draw his own flow charts. I appreciate the fact that we can have intellectual divergences, but those intellectual divergences should be fixed on the record and should not be self-serving and done just for your benefit. It has to speak to the record.
He's not cooking up the figures.
I'm not saying he's cooking up anything. We are in the Republic. He has put together figures. He says he's not cooked it up. It doesn't matter. The point is that documents emanating from official sources will take precedence over his work. And that's what I'm dealing with. And that's what we are obliged by law to deal with, and not by virtue of what is put together documents that he's speaking from home. That's not how it's done. We have to speak to documents from official source. That out of the way. For me as a lawyer and for other people, because he spoke of the adversarial system, the most important thing in this dispute or this discussion is what has been the effect of the law with respect to the figures. And I go back to the first issue. It's very important to understand that when the official administrator was appointed to administer the bank, it was for a period of 6 months. It was at this stage that the figure of 5.7 billion was thrown about. That figure, irrespective of the diminution or the attempt to demystify the caveat in the report, has now been shown to be inaccurate, which puts Mr. Simmons and the receiver on a collision course. Because while the receiver said 5.7 billion then and has revised his position, Mr. Simmons has escalated it. Which one are we to take? I prefer the receiver's one because he's coming from an official source. Now, when you appointed a receiver of a bank, you have 6 months under the law to do your work. If the Bank of Ghana thinks that 6-month period should be terminated earlier, under Section 122, there are 4 circumstances by which it should be done. The bank takes the position that the bank cannot be rehabilitated, the bank has to be liquidated, or there are other reasons. In this present situation, it was never done. It was never done. Therefore, the basis of the revocation of the license in itself was fraught with illegitimacy. And that's the thing that, as a society concerned with law in the adversarial process, we have to be concerned about.
You're talking about the same kind of sin that the Attorney General then flagged.
Well, perhaps we're on the same page.
Okay.
That kind of thinking is not one that I heard Mr. Simmons speak about. He never addressed it. He never spoke to it. He jumped it. But those are obstacles in our path, and they must be addressed. The question which arises for consideration is whether or not the revocation of the license was done properly. 6 months or 6 months period was given for the official receiver. It was not adhered to. Section 122 was completely forgotten. And then they moved on and then they pulled the bank's license. There is no evidence. For example, the receiver, upon giving the official administrator, upon giving the authority to administer the bank, set out a report. That report is not the kind of report that the Bank of Ghana could have revoked the license on, because the bank did not revoke the license under Section 16 of the Bank of Ghana, the Specialized Deposit Taking Act. Even under Section 16, the Bank of Ghana was required to give a month's notice to Uni Bank for them to make representations as to how the bank will have been rehabilitated. This was not done. The question then which comes back to the fore is that in the absence of these conditions precedents, are we not entitled to step back and ask ourselves, how do we move on from here?
So whether or not they gave them the opportunity to proffer an alternative as to how the bank could have been rescued, they still went ahead to do so.
They still went ahead to do so.
They have suggested that they were going to inject 2 billion and subsequently 2 billion, and all of that was rejected.
That is correct. Now, this letter of, if I pull it back here, is a letter of 5th June 2018 in which this offer was made to the receiver. Unfortunately, this was not given serious consideration, and we've come back to square one. Mr. Bright Simmons talks about the fact that the shareholders of the bank had admitted to making recompense of 4.9 billion CDs or much more than that. If you read the letter, they speak of a ballpark estimate. A ballpark estimate. There is nothing indicating a full and complete admission that these were the figures. Remember, the receiver himself was in doubt about the figures. And it is for such reason that subsequently in court, the receiver comes down from 5.7 billion and finally ends at 2.8 billion, pays amended rate of summons and statement of claim. Then the receiver drops down to 2 billion. This 2 billion is made up of 800 in assets, and then you have 1.2 billion owed by third parties, as in creditors, debtors of the bank. The bank is in the business of lending money. So this is where we are when we talk of the bank's liabilities and what is to be recovered. And that's what the Attorney General has done in Nolle Prosequi. When Mr. Bright Simmons condemns that process, he condemns that process without regard to the official record. And he cannot impugn an official record merely because he sits on the sidelines and chooses to disagree. He says that the Bank of Ghana did not agree because they thought that this would not do. Now, the question which arises here is this. At the time this letter was written, this was before the bank's license was revoked. I do not know where Mr. Simmons get his information that the Bank of Ghana thought that this will not work, because finally we've come back to full circle. In fact, if this had been taken into consideration then, perhaps we wouldn't be here. He says that 2 billion cedis in 2018 was not exactly what it is today. But then he does not say.
He's benchmarking with the dollar.
It's a good argument.
Using the value of the dollar.
It's a respectable argument. I would have been happy if you had carried that argument to also debt owed to the bank by the government of Ghana. Are we going to benchmark that to the dollar too? He's silent on that. And I don't think it's a fair argument to make. He has to look at the argument in a holistic manner, especially from where he's sitting. So Mr. Simon's position on the exchange rate should be something that should be applicable to everybody. There's a whole lot of talk about shareholders having stolen money. Such miserable arguments being made but propagated in broad circles. Have shareholders stolen money? Because of these plans, equipment, and property issues and the ratio, the bank had taken the position, which had been brought up at board meetings and approved, the minutes are there, that some of these assets should be held in special purpose vehicles. When the receiver, the official administrator, came upon the bank, these things were disclosed to the administrator at that stage. They were not hidden. And that's why in the letter of 5th June 2018, you see in the third paragraph, they talk of immediately assigned holders' interest in the assets sitting in the books of the bank. Part of other assets of about 3.7 billion, which were purchased by the bank, but registered in the name of holder to improve the solvency of the bank. This will be done together with the repayment plan for the direct loans to shareholders. So clearly, this idea of fictitious entries, yesterday I read a beautiful note by my learned friend on the other side in which he spoke of fictitious loans, and it is for him that I make this point. These things were not hidden. They were put on the books to enable capital exposure limits, exposure limits, and had been put there for that purpose. They were never hidden. They were made clear from the beginning of day that these matters should be put into the system to enable the bank get back on its feet. No tangible reason has been given as to why this was not taken into consideration. He spoke of the liabilities of the assets of the bank having been transferred to CBG. The question is, under Section 1232 of the Bank of Ghana Act, the Bank of Ghana had no authority to split the good assets and the bad liabilities for the receiver and for the taking over bank. All the assets and liabilities under the law are contemplated to be within the bosom of the receiver. That is the law. The law does not say, even though I know this mechanism of structure where you can move assets, good assets and bad liabilities to other places, the law says the assets and liabilities will be taken over by the receiver. In 2018, that was not done. The exchange rate has changed, and today we are being told by Mr. Simmons from a 31st March or 30th March documentation that the assets, the good assets, you should move those 711 million. What was the value of the good assets in 2018? In 2018, when the issue occurred? These are very important questions that we have to look at.
You had mentioned that
yes,
it was bizarre to hear suggestions that some people had stolen any money, right?
Did I use the word bizarre?
Okay, that's my word.
Okay.
And that there was nothing like, theft.
Yes.
The charges, criminal charges, included dishonestly appropriating, or isn't it?
That is correct.
What is that? How is that different from stealing?
It is a semblance of. Prosecutors lay out their theory. The Attorney General himself, clearly in the face of the fact that these monies which go into shareholders for the purchase of the properties or for holder to hold the properties, clearly now sees that because the properties were held in trust for the bank, there can be no stealing here. These properties, at the end of the day, were held for the bank. So that for people to make this argument is based on emotional drawbacks. The properties were held in trust for the bank. And they are on the books. It had been discussed at the board level and it had been approved. And when the official administrator turned up, these matters were disclosed. They were never hidden. At best, they can be called misstatements. And if you go to the company, the Bank of Ghana, the law at 930, if you look at Section 94, I'm talking off the top of my head, the governor, the Bank of Ghana, can examine the books of a bank. And when they examine it and there are misstatements or misapplications, what they will do is that there's an administrative sanction, I believe under 98 to 100, between 98 to 100, where they can punish you by way of administrative sanctions or penalties. Thank you. But it has never been the case that these misclassifications becomes the basis for the revocation of a license. And that's why the law is important. If you put mad things in SPVs, does it then become a basis for revocation of a license? No. It does not become, because the primary remedy under the primary punishment under the law is that when that happens, the person suffers administrative sanctions, especially when the assets have not been looted away but are being held in trust for the bank.
Bottom line,
yes,
the state has a good deal in this approach to terminating the case.
I believe so. An Attorney General's duty is not necessarily to obtain a conviction, especially when the dispute centers on commercial malfeasance, because sometimes it's extremely difficult to prove. Mr. Bright-Simmons was candid enough to say that the Attorney General has gone to court and thinks that within the adversarial system that we operate, this is what he can achieve. That concession that he makes should stop him from making further statements that we have not had a fair deal. Because when we go to court, we operate within an adversarial system. And that adversarial system requires us to operate by the rules. The rules and the facts now clearly show that these are the matters at hand. Their cooperation of the shareholders or the former directors to give to the government of Ghana to recover the 1.2 billion does not make the 1.2 billion a liability of theirs. So we have to get it very clearly. Unless Mr. Simmons can say somebody is stealing money. But there's no such evidence.
The minority has raised some questions.
Very well.
And the public is concerned.
Yes.
That this is an Attorney General who was lawyer for this same party.
Sure.
So smacks of conflict of interest, smacks of collusion to get his client off at the expense of the state.
I recall that in constitutional law class we were taught about the doctrine of necessity. If I became a Supreme Court judge tomorrow, is it the case that if something was concerning an Akufo-Addo, I could not sit upon it? If, for example, I was Chief Justice, tomorrow I couldn't hear the case? The Attorney General has found himself in an office where he has to deal with people that he acted for in the past. By virtue of the doctrine of necessity, he has to take a decision. I always say that when a person exercises a discretion, the mere fact that you have a disagreement with the person over the discretionary use of that power does not necessarily mean that the person is wrong. The question at stake is on the facts available and on the basis of the reconciliation of 2 billion cedis, has the Attorney General taken a decision which is pragmatic, fair, reasonable, and considerate within the circumstances, or should we continue litigating? You have to look at the cross-examination, for example, of some of the bank's witnesses, where, for example, in terms of the capital adequacy ratio, the method which had been used to calculate it, witnesses were pulling back, claiming they didn't even know who had done it. When the 5.7 billion cedis was put to witnesses, witnesses were stepping back as to how that figure had been arrived. An Attorney General is entitled to take a fair position before you lose the case, because you see, in a criminal prosecution, it's proof beyond reasonable doubt. So, at the end of the day, taking into consideration the fact that the revocation of the license was not done properly, and that's a matter that Mr. Simmons, for all his scholarship, does not speak about. Perhaps you do a counterclaim when we are finished speaking, but he doesn't speak about that. And we, for us as lawyers, always say that you can't put something on nothing and expect it to stand. So we have a situation where the revocation itself was improper. We have a situation where the audit figures have kept changing. Nobody can make the reasonable argument, can make the stand-up argument that the receiver is now in collusion with the debtors. It will be untidy to say so. So if the receiver today says in court, by way of his amended writ of summons, as had... Just give me a minute, let me just check.
Sometime in 2024.
20th of March 2024, says that the debt then was 2.8 billion. And remember, at the time that he cascaded down from 5.7 to 2.8, it was not a settlement issue. It was not a settlement issue because they were now getting to grips with the full picture of the situation. That reduction was significant. But then again, the bank had lost its license on the basis of a figure that has now changed. Who is asking that question? Mr. Simmons doesn't speak to it.
From where you said that is an unfair treatment
I don't like
by the state against the bank?
I don't like to put this emotional tax on issues. I just like to put the facts forward. I like to say clearly, or I like to submit clearly, that the figure upon which the bank lost its license has now changed. and it changed in court.
So if they are very, strong about that point, they shouldn't be interested in settling. They should rather be interested in pushing this against the government and seeking that in the end, their license is restored and the government pays for the wrong they committed against them.
The point at stake is that people do not, nobody has the eye of the evil prophet to see tomorrow. Sometimes you may think you have a very good case in court, but the judge may see it differently. And therefore, sometimes when, as they say, what's this thing saying in Julius Caesar, there's a tide in the affairs of men, which when taken at the flood leads unto fortune. Omitted all the voyage of life is bound in shallows and miseries. On such a full sea are we now afloat, and we must take the current as it serves or lose our ventures. Perhaps that's how they see it. I cannot get into their minds. But sometimes it's important to take what you have rather than to wait for the end. The question is, or the fundamental point that we can never run away from, is that the license was revoked on a figure which has now changed.
That's the point you have made a number of times now.
Yes, I was emphasizing this, so I come down to it. So now that we've come down to 2 billion cedis, and the apportionment and the components have been made very clear, and Attorney General is settling on it, people have said, for example, why is he entering a Nolle Prosequi? Why is he not going under Section 35? Why is he not going under the Plea Bargaining Act? Our law makes provision for these things when people are pleading guilty. Nobody has ever explored the thinking that when there's a criminal case running and a civil case running, and the government sees that it cannot win, it cannot force somebody into a plea bargain position, and therefore can enter into a consensual settlement. So I like to say to those who make that argument that clearly Section 35 and 70 of the Plea Bargaining Act are not applicable to the facts of this case.
Because you must plead guilty first.
Yes.
Before there will be a plea bargain agreement.
Absolutely.
Okay.
In this case where it's a 50-50 take, and there's an absence of guilt or admitted guilt on the part of the shareholders, there can be no reference to these particular sections that people are propagating.
Okay.
I'll yield back.
So it's, I'm beginning to appreciate it from this point that it's as if, these individuals are saying, you members of the public suggesting as though we were down, guilty, down, and some favor is being done us. Sorry, no favor is being done us. We don't believe that we would have lost this matter. But Oliver, did you also speak to Ellie when you sought to suggest that the 2.1 billion, which constituted fictitious amounts, and it is not about cash outflows, it's not a matter that you should be letting the people go on. What do you feel now about the developments?
I think that there's so many issues that have come up that we need to take our time with. There's a conflation, first of all, about the questions of revocation. There's questions about how much is recoverable, whether in terms of what the receiver estimates, and also there are questions about violations of law. Now, in white-collar crimes of this nature that we're talking about, it is not a simple question of whether or not a person stole goods and how many goods are. There's a reason why the financial institutions and trading, and also in terms of listed companies, we regulate them in a particular way, because they have the ability to procure significant private advantage that we must be careful of. So, for instance, when you take the receiver's estimation of related party transactions that happen, the law says that it cannot be more than 5% of the bank's net owned funds. Now, those fictitious transactions is to obscure the capital position of the bank in order for you to be able to engage in lending to related parties of up to 5.3 billion. That's a serious crime. There's a reason why we regulate and we try to prevent this, because there's so many economies that have been wrecked by these kinds of conduct, and we want to prevent that. So when something like this happens, and you come back and say that, yes, even though we're doing this and we're manipulating and cooking our books, there's no money lost, essentially, because we still owe you money. The reason why we limit the extent of related party transactions is of the difficulties of recovery. So you might say that, well, it's still loan owed by an individual or an entity. And then we can use the civil term that is non-performing loan. But in fact, what you have done is that you have been able to dip into deposited funds and use it for your own private businesses and refuse to pay back.
May I just say a word very quickly? Okay. I did not say that there were loans given to the shareholders or related parties. I said that these properties were held in trust for the bank, and that when the issue came up, they were disclosed, and that if these were misstatements, there's a remedy and a punishment regime for it under the law. That's what I said. I didn't say there were loans.
So about the point you make, the Attorney General is telling you that, look, I'm looking at the money, I'm looking at the expense the state has to go to seek to recover something. And I'm looking into the future. I'm saying if this matter will take us how many years, by the time we are done, I probably may have nothing, you know, to sort of recover, even if I won. So this is the best way. You say this is a crime for having, you know, make this fictitious sort of booking. Well, that's a crime, so you should be prosecuted. He says, I'm more interested in recovering money than prosecution.
No, this is important. The fact that the Attorney General, and I defer to the Attorney General's logic and how he wants to be able to conduct this matter, says that because of my estimation of the difficulty of recovering certain matters, I'm taking a different approach, does not excuse criminal conduct or criminal liability. It doesn't. It doesn't grant anybody a moral platform to come and now suggest as if they have done nothing wrong in the first place. And it's as if this is where the rebranding of the conversation is going to, that these individuals were completely infallible, did nothing wrong in this contest, and now look, even the Attorney General is now vindicating them. At no point did the Attorney General suggest so. The Attorney General says, I have looked at the difficulty of how we can recover some of the monies made. And when he's talking about recovery of monies is not relating to the crime of cooking the books. He himself admitted that there was a lot of book cooking that happened. So when he's talking about recovery, he's only talking about money that I can be able to get. There's no doubt, even in terms of the receiver's attempts to recover money from Uni Bank, that there's been so many challenges. The matter was first struck out, they went to arbitration, they are challenging the arbitration. We're just going back and forth on the process of how we're able to recover the money from.
In 6 years, so you see witnesses.
This is a question that invites us to be able to relook at our judicial system. It is not a question to now allow other people to suggest that we were always holy in the first place. And that's what I kind of see a rebranding of the conversation.
They say that they admitted from the start, from the outset, that this 2.1 billion is money that, you know, was fictitiously
now, you see,
put
I have never
so they haven't said they
I have never held a million cedi before. So when I hear things like it is only 3.7 or 2.3 billion, I quiver in my boots to say that we are talking about huge sums of money. When somebody says that, oh, oops, you caught me, I can bring back the money and be free. What are we talking about? These are huge sums of money. So it's a question of also, again, the criminal justice system is not only set up as a state for the recovery of monies alone. And if the driving logic is that whenever people caught themselves in this case, we take how much we can get and go away, we must think about the repercussions of whether or not we are disciplining conduct within the banking system, generally for everybody, for the posterity. So I have no problem if the Attorney General says, even if we are going to lose this money, posterity and the health of our economy for the long term requires that we must take these decisions and go forward with it. Even in the question of the wage capital, but even though money has been, well, let's say at the status of affairs now, that the Attorney General says we've lost the criminal case, it doesn't stop a civil case from going forward. A civil case is a recovery which is a bit different standard of proof. So it doesn't stop that. Recovery can still pursue. Civil recoveries can still go on.
And this is a point the Attorney General has affirmed.
Yes.
That is a civil process that it seeks to recover money.
So the civil process must go on. But the criminal implications of individuals within our society that are able to misuse public depositor funds or obscure their use of depositor funds and then invite the state to put in money, so much billions to be able to save them because too big to fail, or you must be able to protect depositors because there might be a run on fund managers and other things.
Does it not matter, or does it matter that the bank's exposure to the government was partly the reason they were in the circumstances
I see these
they
arguments all the time. Government borrows money from every bank. The portion of what the government owes the bank does not impair the bank's capital ratio position. Like, it is not so significant as to be an excuse or a red herring that we use to divert the conversation. Yes, the government owes everybody. The government owes individuals who are waiting for tax refunds. It doesn't mean that when they commit crime, you said that you owe me money, that's why I couldn't pay, or I was hungry at a particular time. That's the kind of straw argument that is being set up in this case. So the question is, in the significant time when the decision to revoke the bank, the license was made, was the amount owed by government so significant that if it was paid, it would have saved the bank? No. There's a suggestion, and what you have referenced to, Dame's advice. Dame's advice is not saying that the revocation is incorrect and improper in law. Dame says that his view is that Section 114 cannot lead to the appointment of a receiver or the termination of a license. He's referring to the report made under Section 114. He has not said at any point that the Bank of Ghana cannot exercise its powers. Based on the information that was received from the receiver, and say that there's been Section 16 breach, or for which reason I'm going to under Section 123 and appoint a receiver. There's nothing that impugns that decision that the bank is capable to make. In fact, the only basis, and it's not true that the only basis under which the Bank of Ghana can revoke a license is when you are not able to refund money or other things. If you have been given a license, you're supposed to respect the body of our laws under the law, and you have shown consistent disregard for those laws, which has led to significant impairment of your capital position. The bank says that, no, this is not a bank that can be run honestly by you individuals, and so I can revoke that license. It's a different matter. And I know that whether they are entitled to pursue it or not is different. But there's an important concession that he made even in his speech, which is that our decision, you quoted a poem, that our decision whether or not to go and pursue those claims is that you must also evaluate other factors. It is the same other factors that the Attorney General is evaluating in this case, because we know how the nature of the judicial system is, and has decided to take a particular position on it. There are three things that I will take as a problem with the Attorney General's position. One, I think that in the matter where people are becoming growing suspicious of your own role in the matter previously, it was not sufficient to issue that statement that they did, which said we have recovered 60% for which reason you have dropped. We should have been brought through a workshop process where we understand reasoning before you issue that kind of statement. So that was a failure in the first place. It is not true, and this suggestion that because you once acted as an Attorney General, you are compelled by necessity to be the ones who is involved in that role. We see that same of thinking that we are challenging with respect to empaneling powers of the Chief Justice and other things that we are doing in this state. When the Attorney General in Trump's case decided that Trump was being investigated, he decided that he was going to build a Chinese wall, appoint other competent individual to be able to handle this case and advise the Attorney General properly. There's nothing in our laws that stops the Attorney General from having a special counsel, from having any of the other officers take the lead on this matter because of his own previous dealings, irrespective of your power. The fact that power that exists doesn't mean that remedial actions cannot be taken to be able to insulate yourself from the decision-making process around this, particularly when it is legally possible of legal contention. So that's the second thing. Again, it's not about whether or not he's wrong in his assessment, but the appearance of, Martin Abidi talked about the former lawyer of Dufo was negotiating with himself as Attorney General. These appearances in a public policy matter can create impressions that weaken trust in the office. And it's about protection of trust in the office. Thirdly, when you are making the decision regarding what is recoverable or not, we do not know the extent of conversation that has existed between the Attorney General and the receiver and the implications of the receiver's work. We don't see the receiver speaking. We don't know what extent of what collaborations or discussions have had and whether or not it compromises the civil matter or not. So when Bryce says that the receiver is the only person who is competent in law to recover money, he's technically correct. That he's still in a fiduciary responsibility vis-a-vis the Bank of Ghana, who has expended those amount of money. What conversation was had between these?
Will anything change if I told you that the receiver endorses 100% the position of the Attorney General as put out?
I think that it is important for us to know that the receiver would then communicate this matter to us. I think that it is fair. I am not discounting the possibility of an agreement that's viewing the difficulties I've had even within the courts in trying to recover this money. Because the essence of the criminal prosecution system, and Bright says this, is that it also allows pressure to be brought to bear on the individuals for them to be able to deal with the receiver in a particular way. Because if it's left with the civil justice system, well, we can be in court for 100 years.
Does it also matter on the other leg of the suspicion of complicity or some wrongdoing for his own former client? When he discloses to us that a number of people were involved in this negotiation. It was a prolonged negotiation. There were officers from the Attorney General's office, including, is it the DPP, the Director of Public Prosecutions. So it's not as if he single-handedly led the process.
So when the NDC was campaigning to be elected, they said clearly in their manifesto that they were going to conduct a forensic audit of the entire banking sector cleanup. The expectation then is that there's a plan and a roadmap that Ghanaians will be privy to as to how this was going to unfold itself.
Potentially to restore some licenses.
Yes, and potentially to do all of that. Now, we haven't been given the benefit of a holistic review as it stands, and then be able to assess how this decision-making was going to happen. Now, I said that the process of how we reach the decision, that has to be sufficiently workshopped with Ghanaians. that if the Attorney General, who is clearly not media shy, had come out at the beginning and said that with a specific question of Uni Bank, I am concerned about the delays in trying to recover. I'm concerned in the state's case against them in the criminal process. And so this is the procedure I'm going to put in place. And whatever comes out of it, I am going to abide by because of my own previous dealing with it. Unless I feel that I have an ethical duty to protect the Republic, even in the instances where the committee or the process I've put in place does not go far enough in the protection of the Republic. If we have been brought along in this process, I do not think that anybody who then sees that the Attorney General has said that this is what we have done, and this is why, on the basis of that, we have taken the decision, will be so aggrieved. It is the absence of information, particularly in a state where people have grown accustomed to elites getting away with crime, that people then feel sort of heart-changed. And it's a damage to his own credibility and reputation that he did not think as a politician in this process. And what do I mean by this? A politician carries the people along. So it is not just a technical question of what lawyers do in the closed confines, but also how you bring the public along to buy in the end result. So we don't take that for granted. I think that they took that for granted in just trusting his personality and what he says at the end of the process.
From where the receiver sits, and I'll bring in Vicky Bright now, from where the receiver sits, in fact, when you say the recovery is 60%, from what I've become aware of how the receiver thinks, it's actually potentially beyond 60% recovery. So the criminal case involved transactions amounting to 1.2 billion, out of which the accused persons have committed landed properties valued at 824 million towards the settlement of their debts. They think that that would amount to a recovery of over 60%. In fact, that would be 69% in that case. In the civil case, the amount totaled 5.7 billion, including the amount in the criminal case, which has now been revised to 3.3 billion on account of the fictitious loans recorded on the bank's books, which do not involve cash outflows. Based on this, the people involved, the accused persons, again propose to settle through what they say is a structured, approach. The sum of 2 billion. They can see this clearly as yielding a recovery of over 60%. Once again, this will be precisely about 61%. What do you say?
I think I want to just make some general comments, because I guess if I were to sum my view on this, and we've all listened extensively to a lot of analysis on this, I would say that I'm not happy with the decision, but I can understand why the Attorney General made that decision. We, under Nolle Prosequi, we know that he's not obliged to explain himself. But for the purposes of transparency, he chose to do so. And I am glad he chose to do so, because if he hadn't done that, some of us would have sat there scratching our heads and wondering, what's going on? Is this the new normal? Are you opening the floodgates to allow people to steal and just steal enough so they can have the pot to negotiate their way, and keep the rest of it? But and I would also have been wondering how this sits with the oral, process, the oral anti-corruption processes that are going on now. So for me, it was good that he did that. Maybe now we find ourselves scratching our heads about something else, the figures, which you were talking about. I want to say that the way some of this has been packaged seems to suggest that it's bad, but it's not so bad. These are real crimes. Let's not be confused about that. And these are very serious crimes. So I would not want the gravity of the offenses to be understated. I think it's important that we get that, you know, because the Bank of Ghana is there as a regulator for a reason. And not everyone is allowed to hold a universal banking license. You have to go through very rigorous compliance procedures to be awarded or given
the Attorney General says he would
license.
He would also love to have convictions. But he says he's being pragmatic.
Yes.
And he's taking a holistic approach because 100% recovery was not possible and a conviction was not guaranteed. Is this a statement of fact to you? Is this a statement of fact, reality?
I think in reality, look, when you go through all these cases internationally, it's 100% is never possible, is it? So everyone tries to get as close to it.
Conviction is not guaranteed, is he right?
And conviction is never guaranteed either. I mean, these are just mere facts of life. You know, sometimes you go to court and you expect to get a conviction and you don't. Other times you expect to be free and you are convicted. So just as a general rule, that is a fair statement. Whether or not that applies in this particular context is another matter. You know, this whole non-conviction-based asset recovery scheme or regime that we now find ourselves in is also interesting here. I know that in some countries, like the LATAM countries, for example, they have them for even drug trafficking and corruption charges. In Colombia and Peru, they have actually enshrined this in their legal system. And then when you come closer home to Africa, Angola, Cape Verde, Mozambique, and then, you know, the UK, whose laws we follow very closely, they also have it in both their civil and criminal proceedings. So for asset recovery orders and forfeiture orders. So I think that...
but that nomenclature, it might be problematic. And last week, when we were discussing the same issue, people have said, you know, non-conviction-based asset recovery. This is not what that is. We presently don't have that sort of, you know, legislation
enshrined
for
in
it.
Yes.
But non-conviction-based forfeitures are supervised by the court. That's what they are. It's not you, the person involved or the accused person sitting with the Attorney General, prosecutor, and agreeing, and the Attorney General going to enter a Nolle Prosequi.
That is correct.
Because this is beyond the reach of the court.
Yes.
Once you file a Nolle Prosequi, the court can't say anything.
Then the Attorney General is a law unto himself.
So we shouldn't be calling it anything like non-conviction.
It's similar to it. It's not exactly the same thing, but as you said, this one is not. It's just a regime. It's a power that the Attorney General has and can exercise. And I'm thinking that he has this kind of regime at the back of his mind when doing these things.
Again is applicable. That again is applicable because we need to educate our audience too.
Yes.
It's applicable to where the law enforcement ascertains and makes the conclusion that you have what your income cannot explain.
Yes. Yes.
This is a completely different thing.
Yes.
Like in the Constitution, Article 2864.
2864.
That if after your declaration of your asset, if we find that you have something which is not attributable to your income, attributable to inheritance, a loan, or reasonable earnings, then that will be forfeited because it is
you can't explain it.
You can't explain it.
Yes. So, well, anyway, this is the route that he's chosen to go. And you know, we are where we are with it. So what I'm trying to say is that the context which he provided was helpful, because without that, I think there will be serious questions that would have been asked.
Okay.
My question, which I'm asking myself, is that where is the punishment in all of this? Because there has to be a punitive element. Do we, for example, are we saying that these are people, or should we say, or probably we should say, that they should never be allowed to run a bank again or any financial institution again. They should not be allowed to even be directors of companies again because you have managed things so badly.
Those are the rules, actually. So that is the situation. If your bank's license is revoked or your financial institution's license is revoked, this is the consequence you suffer.
Yes. Yeah. So we just have to make sure that, because they have a lot of related companies. They have a lot of related companies, and we are being told, in Bright's expose, he said that some of these related companies have been resurrected or disguised under other names.
Almost 30 of them.
Almost 30 of them. So when I say what I say, I'm stretching into those related companies. Because yes, under Act 930, it's clear that what the consequences are. But we have to look beyond the face of it and look into some of these related companies. These related transactions that they've been involved in and all that. I mean, there's a lot of deception here. You know, a lot of deception and just hoodwinking the regulator. You know, and I'm not saying the regulator is innocent, because they should also have been able, their audit should have actually disclosed some of these matters. So I guess that's another argument for another day. What we all take heart in is the fact that with the Nolle Prosequi, the door is still open for punishment. Should they come across any new information or evidence that will warrant the case to be reopened. So I guess it's been parked rather than the doors shut firmly. Because if he had done a withdrawal, that would have killed the case.
A withdrawal after prosecution had closed their case. After prosecution had closed their case, then that would have actually shut the thing down. But he chose to go down that route. So the fact that we can, you know, I guess the door is ajar, it's not completely shut. So let's see what happens next. So, Abraham, Dr. Nyaho Tamaklo sends in this message. He says the recent Uni Bank case where the Attorney General utilized the Nolle Prosequi to discharge Dr. Dufour and others served as a stark reminder for our political class to tread carefully in handling sensitive matters. The application of such legal instruments, while within the bounds of law, can be perceived in various ways by the public. It's crucial for leaders to consider the implications of their actions on the populace. Given the general public's limited understanding of the legal intricacies, it's imperative that electoral promises are honored to avoid perceptions of being taken for granted. The trust between the governed and those who govern is fragile and must be nurtured. When promises are made during elections, there is an expectation that they will be fulfilled. Failure to do so can erode this trust and have far-reaching consequences. This is what Nyaho Tamaklo is saying you are bringing upon yourself, that the goodwill that you have as a government is eroding. You are losing it.
Samson, I don't think this falls squarely under what Nyaho Tamaklo is talking about, even though he's talking about it. You see? There's a saying in our language, that's you and me's language, that if grains pour in the soil, you cannot collect all of it.
Correct.
That's a fact. Now, you have an Attorney General who has inherited a case which has been running for 7 years. He will definitely review the case. And don't forget that anytime you put together lawyers from the Attorney General's department to prosecute a matter, it is an expense to the state. He then reviews the law, the case, and this reviewing of the case will not be done only by him. So he comes to a conclusion that, look, in this particular matter, I cannot guarantee conviction. In this particular matter, why don't I cut my losses? And takes a decision of this nature. He looks at it and says that the state will benefit if I engage in what we are calling non-conviction based assets recovery. as a nation and as a people, are we interested in recovering what has been lost? Or we are interested in seeing the full haul of the case, and then at the end of the day, if they are acquitted and discharged, we say that Attorney General has done well. Which do we want as a people? In this particular matter, I've heard that Dr. Ayene acted for Dr. Dufour. Kwame Akufo has rightly indicated the doctrine of necessity, but let me also place on record that he only appeared once. It is not as if he conducted the case. At the trial, he wasn't part of the case. The case was actually taken over from him to Kwame, Safo Boabeng, I think so.
That's correct.
Yes. And so, those who are talking about the fact that Attorney General is using his position to, as it were, free NDC connected people, I ask the question, why is the prosecution also only about the NDC connected people? Why is the prosecution also just about NDC connected people? So, I am of the view that once the Attorney General has taken this decision, we need to subject that decision to scrutiny. Is it actually true that 60% had been recovered? We need evidence to show. That for me should be the argument. That for me should be whether it is true that the state will benefit from this 60%. The next thing is to say that...
Before you go to the next thing, you just a while ago endorsed the doctrine of necessity as espoused by Kwame Akufo, right?
Yeah.
Not too long ago, the Chief Justice was embattled, and there were cases that were going in the courts concerning her, and she was still empaneling the judges. You were very unhappy about that when the NPP kept saying that because of the doctrine of necessity, once she still remained the Chief Justice and she had not been suspended like she now is, it was her duty. She and only she could empanel the court.
But don't say Dominic, Samson. People will make suggestions. People will make comments. The position is that she did it and she was in the right to do it. But you can't stop people from making comments.
No, I'm saying,
yes,
you were unhappy about that situation. You criticized that situation, that it ought not be. So why in this circumstance you say, as for Dominic Ayene, the doctrine of necessity must apply to him?
Samson, I have indicated to you that whatever decision you take, once it's supported by law, doesn't mean that people will not still feel uncomfortable about. But at the end of the day, her position prevailed. And so this is also one of the situations where the doctrine will apply, and it will apply in favor of the Attorney General. The other thing has to do with the fact that if the Uni Bank matter, which is before the court now, which is before the Attorney General now, and he has, as it were, provided this way forward, are we also going to be interested in whether or not the state has violated the rights of Uni Bank? When procedures that were supposed to be followed for the liquidation were not followed,
The revocation
rather, were not followed, are we going to be interested in that? And I also disagree with my good friend when you spoke about the fact that what government owed Unibank was infinitesimal. It doesn't matter. Would that have also helped Unibank to show up its books? Would that have showed the Uni Bank books, which would not lead to the revocation of their license.
The receiver, that's the Bank of Ghana appointed at the time to be in administration of Uni Bank, had called on the Bank of Ghana and say, you owe the bank, pay the bank. Right? It didn't matter that it was the Bank of Ghana that appointed it, the receiver or the administrator, official administration to be in it. He still said, you owe us, pay us our money. Because maybe you can help us to stay afloat.
Because there were a lot of contractors who had gone to that bank and secured loans to do government work. Government failed to pay the contractors. The contractors couldn't also pay Uni Bank. Was Uni Bank also, exposed by that arrangement from the state? And I think that the current situation where the Attorney General has come out with this type of situation is best for the Republic. And like Vicky Bright indicated, the Nolle does not, as it were, and I heard the Attorney General make that point during his press press conference, that if they stumble on new information, they can still pursue them because the Nolle does not end it all.
Do you believe that?
Why don't I believe? What, do you have anything was anything written on his face that you don't believe? Something?
You mean an Attorney General in a different regime?
No. What's wrong?
This regime.
Why? This same Attorney General was then an Attorney General and prosecuted an NDC person. You know that. This same Attorney General, Dominic Ayene, prosecuted my own brother.
Interesting. So those of you who are a bit worried that it doesn't look like we have sufficient time, let me let you know that we have an extended time, and that's why we are taking time to make sure that we discuss this matter thoroughly. Kwabena Boateng, what do you say? The minority held a press conference led by Kwame Ayimedu-Antwi, and they raised the issues of the optics that didn't look good because of the Attorney General's previous, position as a lawyer for Dr. Dufour, Uni Bank, and so. When you hear that whether or not he was a lawyer for him does not change the figures that we are speaking to. So what's wrong would have been occasioned?
Yes, it may not change the figures, but obviously it will influence one decision or the other. Because we all know that the decision to prosecute or not is one that is reposed in the AG. So if he had previously acted for a party, and not the usual clients lawyers would have, but one that is also a member of his own party, a leading member of his own party, nobody can rule out that affinity that can breed some influence.
Do you think sincerely that there would have been an Attorney General or deputy within the NPP's regime who would not come into contact with their clients after they had become Attorney General? Because the Attorneys General are experienced lawyers. They would have had many years of practice. They would have done maybe 15, in the least. I don't know an Attorney General who's done less than 10 years in practice. So they will have clients, and they may come in contact with them when they are executing their job as Attorney General.
Yes, in fact, I agree with you. And, sitting down here listening to the arguments, exactly what I was thinking was for us to begin to look at that area as a nation. Because, obviously, as you did indicate, as a lawyer, you obviously, have clients. So if you come into any statutory positions, one of those clients may, have a case that you would have something to do with in your official capacity. But I will also defer to the argument made by my brother that in instances like that, it is very important that we create some insulation, some buffer between the AG and then those who will have the hands-on duty in respect of that matter.
The ultimate decision will be that of the AG.
Yes, and that is also problematic because The AG mentioned the DPP and other people that were involved, but these are also people that, work under the Attorney General. So the influence line is not truncated.
They're professionals.
Yes, I agree. But then it is also a perception, and the perception is very important, very, very important, especially in this enterprise, of governance. And that takes me even into the public trust in the whole criminal administration system. What we know and what we know to be the jurisprudence of our criminal justice system is that inherent in it is deterrence. And that is number one element that runs through our criminal justice system. If you take that out and then we begin to wade into other issues with economic motives, then we are losing what primarily our criminal justice system is supposed to do. The public expectation is that if you do wrong to the state in a manner that has been done, you should be punished. When we are talking about punishment, we are not only talking about custodial sentences, but at the end of the day, there should be a certain pronouncement, judicial or otherwise. There should be a certain pronouncement on guilt, which will go with you with all its attendant consequences. But if we begin now to be saying that, once we can get something, once we can begin to negotiate and be able to recoup, what we have lost, then we can replace, what is the criminal justice system is supposed to do. We can replace it with a civil arrangement. It becomes difficult, and this is very, very fundamental. Very, very, very fundamental. I think that it will begin to create problems for us. The public will begin to think that, and especially will not be good for the political class, because what will happen is that you have people who are too big to be jailed. For offenses that people have gone to jail for even lesser, offense. It doesn't look too good for the political class, and then the whole integrity of our criminal justice system. Again, I have problem with the position of the AG in respect of the difficulties that he professes, with continuing prosecution. Reading his presser, I don't.
6 years.
Yes.
Only 2 witnesses so far.
Yes, we have had cases that have traveled decades. Even some that has to do with, mainstream crime, murder. When it is assizes period, you have cases that have traveled over. But those do not become the reason for abandoning prosecution. I'm one person that would not want to see, anybody in prison, and obviously not a senior citizen like, Dr. Dufour. And that is why I rightly indicated that we are not all talking about imprisonment, but a certain judicial pronouncement, which will give a certain, trust on the part of the people in respect of the system that we are all running. The AG does not even pay filing fees. So I do not see the whole argument of cost. Is it?
I say you don't know cost incurred by prosecutors when they go to
so if you are talking about, are you talking about salary of
talking about time and everything?
When you
yes, but we do so for all other cases. We do so for all other cases. If you go to the registry of the court, there are so many assault cases, there are so many murder cases, so many other cases being prosecuted by officers of the Attorney General's office. Why is it that in respect of this one we are talking about cost? And cost in respect of what? More so when you do not pay, filing fees when the state attorneys file their documents in court. I don't see it. And I clearly do not also see the difficulty If you say that conviction is not guaranteed, in which matter can you 100% guarantee conviction? Not even in murder. So when we go to court, our duty is to put our evidence before the court, and for the court to look at it, evaluate it, and come to a certain conclusion. There's no single matter that you think once you institute it, the outcome is
There
secure.
are some matters you have ocular proof. So it's not too difficult to say this matter.
It is still subject to the
definitely
judges. You'll be
saw the
surprised.
OSP and the video of the bride. Even ocular proof, we are not able to
Sometimes, yes, and sometimes the frustration on the part of lawyers.
That was an interesting situation, right? The problem with that case was that while he gave the money, and you can see that money exchanged hands, he doesn't say specifically that I'm giving you so you vote for me. But they show the video where he's demanding a refund of the money because he did not vote for him. And yet the judge says there's no proof that this was the purpose of the money.
That's the problem sometimes. And that's why I quoted the poem. But there's this stringent attitude by my friend here, my learned friend here, to speak about conviction. And I have to say, if you look at the Epstein example in America, when Trump was in opposition, he kept on belaboring the point. Today he's come back to haunt him. When we speak as lawyers, we have to use the threshold of objectivity to ensure that when tomorrow we are back in office or we have official powers, we are not caught by our own languages, like my friend here started struggling with the doctrine of necessity.
So let me take very quick comment from Bright to conclude. So we move on to the next subject. Yes, Bright. Hello, Bright Simmons.
Thompson, can you hear me?
I can hear you clearly.
Oh, very good. So I need to make a few reactions to
the manner, for example, the manner at which you arrived at the 10.6% is flagged as clearly unfair.
Well, there are a couple of points that I think we have to make. So one of them is that my very erudite colleague on the panel, Kwame Akufu, clearly evidences why Uni Bank retains him. So he's done good advocacy for them, as I'm sure he's done in court on other matters.
What is Bright saying?
That's good.
Bright has had the advantage of sitting at home and preparing his notes. You have notes all over the place. We have to speak extempore. I don't even know why he's getting the right to rebut her. You sit back, you watch us, you file pleadings against us.
You directly address some of the points I raised. So first of all, I think it's important that the audience know you are a lawyer for Uni Bank, has been for a while, so they understand the full context. The second thing I think is that you mentioned the SPV loans, and you try to suggest that all the related party transactions are SPV loans, and that is not correct. The SPV loans is what I've displayed on the screen. If Samson, your viewers can see, and
it's very clear.
Can they see?
Yes, it's on. Except we want you to be very quick about this.
Basically, what happened is that monies that were given to the shareholders by Uni Bank, some of them were then packaged into entities that the shareholders still controlled, but they classified them as SPVs, and the amount involved was just 650 million cedis. So in terms of the total, this was still around 15%, right? So even if you assume that the SPVs are innocent in some way, it doesn't cover the huge amount of money, nearly $1 billion, that was given to the shareholders to invest in various other transactions in companies that are still active and which is still making money for them. So essentially, the issue is really simple. It's a very simple issue. When Uni Bank collapsed, how much did Ghana spend to try and fix the problems that were created, including nearly $1 billion in deposits that people had gone and given to Uni Bank, for some reason we couldn't find money to make good on those deposits, and the government had to step in and put in that money.
But they're arguing that that's your own problem as a government. As far as they are concerned, they were going to inject 2 billion, is it 4 billion in total? The bank would have survived.
It's very important that the numbers, we don't get confused with the numbers. There's a certain amount of deposits people have gone and put in a bank. That's number one. There's a certain amount of money the Bank of Ghana has given to a bank, which is our money, the people's money has gone to a bank. That's number two. The bank has borrowed money from other banks in Ghana, etc. So that's number three. When you add all that up, how much do you get? And that is where you get the 9.4 billion. That's number one. Number two is that, and then when the time came and we had problems with the bank, and we said we're going to revoke the license, remember that under the law, if the Bank of Ghana concludes that the bank is insolvent, the law says it shall, it doesn't say it may, it shall revoke the license within 60 days. So once the Bank of Ghana established that the bank was insolvent, the Bank of Ghana had no further discretion in the matter. The bank had to be resolved. Now, in the process of resolving the bank, we now say, okay, this 9.4 billion that we know you owe people, where are the assets that will cover it? We couldn't find those assets in enough quantity, which is why the people of Ghana stepped in. And what I'm trying to explain to you throughout is that in the end, we spent about 7 billion trying to cover the hole that was left by Uni Bank. That is the big issue. Most of these other discussions we've had, while important, does not in any way diminish that critical point. That in the end, you and I, everybody had to pitch in our taxes to cover the hole that Uni Bank left. Whether that was due to negligence, theft, misappropriation, etc., we can debate ad nauseum.
Okay.
Last, which has also been, I think, not sufficiently covered, is that when I showed you a slide that showed how much money went into the big companies that Unibank owned separately. I don't think we paid attention. These are companies that are not SPVs. These are companies that are still operating, and they are still controlled by the shareholders of Unibank.
He said.
Numa, Integrated Properties, Uni Precision, Alban, Eurostar, Belstar, etc. Now, those companies, when you look at the monies that was given to them from Unibank, Numa Logistics alone, nearly 1.7 billion. That's roughly $400 million of loans taken from the bank and given to another company controlled by the shareholders. Now, these companies are operating, they are making profit, and I'm sure the shareholders are benefiting. My argument is there is more that we can squeeze out than the $60 million in properties that have not been valued.
Right.
And the $2 billion we should collect from other people other than Unibank. Essentially, as a country.
So, Bright, I did pay attention. That's where I suggested that it appears that you have done a better job than all those who have produced these reports.
No, not really. Because the reports, everything I said on this show came from not one report, but several reports by the receiver. That's the point I've been trying to make. So when Kwame Akufu insists that I've sat there and calculated my own figures.
No, I'm not insisted. When you make the statement, for example, the properties have not been valued, it's incorrect. The properties have been valued and taken into consideration for purposes of the reconciliation. It's incorrect for you to make that assertion.
And those documents that the receiver...
You agree, Bright. You agree, Bright, when you say those properties that they have, tendered for valued at 800 plus million, you said no one has valued them. That was an unfair statement.
I'm saying that they are yet to be valued.
How do you know that? Because they are valued, and that's why they put a figure to it.
No, the Attorney General says it depends on how they realize it.
Well, there we go. Now he changes his shifting sands now. Depends on how they did what.
I'm saying that the Attorney General himself announced that those properties, depending on how much they are valued at, if there's a shortfall, that will have to be covered.
Okay.
So that tells you that we already have a risk.
Thank you, Bright.
Every document I've used on this show
they were valued by
from the receiver.
They were valued by three entities, including
thank
the
you, gentlemen. Thank you very much, Bright.
Let me clarify that last point. Every document I've referred to on this show, every single one, has come from the receiver, and they are as official as the documents that Kwame Akufu has used. So they know that there's a presumption of regularity that benefits his position but does not benefit mine. It's not correct.
Okay. It benefits me. Thank you very much. We'll have to find out how the receiver is unable to come to the same conclusion as yours, and the huge gap as far as the debt obligation, calculations by yourself and the receiver is concerned. Yakubu Ibn Chambers says that as peculiar as the purpose of a sensitive institution like the bank is, I find it preposterous that a bank like Unibank could muster the temerity to engage fictitious figure entries meant for consumption. It will only be an exercise in futility because the Attorney General is politically aligned with the individuals in the Unibank case. The Attorney General should do Ghanaians the favor by distancing himself from the recovery process. D says that, can you ask Kwame Akufo, has the figure changed into a new figure that would have saved them from losing the license, or the figure changed into a new figure that's more of the same predicament that would still have saved their license? Okay, questions there. George says, conflict of interest. Official duty ought to be done by the one authorized to do so, even if his deputy were to take that decision in Dufour's case, it would still have been done in the name of the Attorney General. The Attorney General found himself in a difficult situation, but then he ought to perform his official function. Right. Many of your comments, we need to take a break and return to, disguised SML at the airport, where broadcaster Paul Adumochire is being investigated among a number of people for something that must have gone wrong, criminally wrong, and for which he was arrested, detained, and eventually granted bail yesterday. Ayene's apparent conflict of interest also stems from a pattern. Was Stephen Opuni not also his client? Did he not file a Nolle Prosequi in that case? That's a question from Kojo. And Musa says that, Abatua says that Attorney General's decision to discontinue Dufour and 7 others' case, for me, is a prudent decision. The so-called banking sector cleanup was nothing more than an avenue for two things: siphoning the public purse and persecuting political opponents. If not, why did the government target only banks affiliated with the opposition? And why spend 25 billion? It's actually 30 plus billion, 31 plus or so billion to collapse these banks, when just 9 million billion Ghana cedis could have kept them in business. Simply doesn't make sense. All right, we take a quick break. We'll be right back to visit the OSP to look at what it is doing wrong. Paul Adumochire has put up a video thanking a number of people, and people are getting incensed at that particular video. He's mentioning prominent figures in this country who called him, and he suggests that they seem to say, sympathize with him, and seem to suggest that what he has said, he was being witch-hunted, could be the case. We'll be right back.